Well, my name is Orlando Portela. I'm an immigration attorney here in Jewish Family and Community Services in the legal department. And I would like to share with you one of the legal relief that the unaccompanied minors are available to use if they qualify for it when they arrive into the United States. And that's the SIJ status. Basically, the kids that are in the shelters, as I was telling you in previous videos, have about four main possibilities of legal relief in the United States under the immigration law. One of them is called the SIJ, the Special Immigrant Juvenile Status, and another one is the asylum, another one is the U visa, and the fourth one is the T visa. I'm just gonna, in this video, talk about the SIJ status. This is an immigration relief that only applies to kids that are under 21 years of age, that are not married, that arrive in the United States but were victims in their home countries, either of abuse, neglect, or abandonment by one of their parents, maybe by two of them, but at least by one of their parents, and that is not in their best interest to be back or to be returned to their home countries because of that abandonment, abuse, or neglect that took place originally in their home countries. If you had a kid that you could interview and have any of those elements, then you said, well, maybe there is a possibility. Maybe there is the possibility for the SIJ. It is a very complicated thing in the sense that you have to do different jobs in different scenarios. And there is no specific order, or all is going to depend on the case. Sometimes the case in immigration court started before. Sometimes you can go to a state court before the immigration court starts. There are different settings and it could vary, but basically there are three different scenarios. One of them is the state court. And maybe you will ask, and why, if it is an immigration case and immigration matters are of federal nature, why do you have to go to the state court? Well, the thing is that immigration law recognizes the expertise of the state courts to make some determinations. The determinations regarding the status, the legal status of the kid, in the migratory status of the kid, are for immigration judges to do. They are going to decide if the kid could stay or the kid have to return. That's their decision. But as I said before, in order to qualify for an SIJ, you have to prove that you have been abandoned or abused or neglected by your parents. And that's a determination for which the immigration judges have no previous experience, have no expertise of doing it. So they delegate that determination to the state courts. And usually, well, in the area where I work, which is the city of Pittsburgh, it's on the family court. The family courts, the court that takes usually determination regarding custody of the kids, regarding abuse of the kids, regarding dependency of the kids. So you go to that court and you will need an order of that court saying that the kid was a victim of abuse, abandonment, or neglect. Once you get that order, then you can go to another scenario, which is the administrative scenario. You go to the USCIS, which is the United States Citizenship and Immigration Services. And in their office, you have to file documents in order to ask for that kid to be considered for an SIJ. So you have to add the order from the family court that got the determination of abuse, abandonment, or neglect, and also have to include determination regarding the custody of the kid, and have to include determination regarding the well-being of the kid, where the kids is going to be better, the best interest of the kid, if he have to be back in the country or here in the United States. Well, you include that with your petition, and there start a process in the United States Citizenship and Immigration Service regarding that, and they could approve or not the SIA status. While they do that, that takes a month. While they do that, you also have the removal process, because these kids, the United States government is trying to deport these kids. So they already went to immigration court usually by that time, and they started the removal proceedings, and you have to be there also representing the kids and trying to buy some time for the kids to finish their petition, their SIA petitions, and have those petitions be adjudicated by the immigration officers. If everything goes right and the kids receive that petition approved, like they receive the status, the SIA status, then it's not over. Then you still have to wait. There will be a priority date in their approval notice, and the next step will be to make a change from that status to a permanent resident status. Why? Because the SIA status is not a permanent status. It's not a status in which the kids are allowed to stay living forever in the United States. The SIA status just allows the kid to present papers to adjust the status and ask for a permanent residence. There is about a 3-year span that kid will have to wait in order to be able to submit the papers for the permanent residence. If they waited that period and they submit those papers, then they have to wait again. There is a process to get their residence approved. If they got that process over and received the approval and they are permanent residents, then they have to wait 5 years in order to qualify and ask for the citizenship. So it's really a long process. It is difficult, but it's also satisfying for us attorneys and the people that are working here with us, helping those kids. Well, I really hope this series of videos have been helpful for you to understand the situation in which those childs that arrive to the United States are situated, the situation they are living in. If you have any questions regarding this, or if you feel like you wanted to help, just please contact us. The contact information is here in the video. Please just move forward, take the step and contact us, and we'll try to get back to you. And thank you, really. I appreciate any efforts that you make in order to help these kids. Thank you.